Welcome to Unit 1.3, Linguistic Canons. We're going to be going over several different linguistic canons, which are going to be a little bit tough to absorb initially. It's common to spend a whole semester on these canons when we teach a 1L law course on legislation and regulation. What you're getting here is a very condensed version. So if you don't get these all right away, don't worry about it. But I want you to have a general sense of how the language of the statute is used to figure out the meaning. So the first canon we're going to talk about is in pari materia. And there are actually two aspects of this. One is the whole act rule, and the other is the related canon rule. So I'm going to go over both of these. So the whole act rule says that a section of a legislative act should not be interpreted in isolation. You would want to look at the act as a whole. So an example of this would be interpreting all parts of the US Patriot Act together instead of looking at one part in isolation. The related statutes canon is not looking within an act, but across different statutes. And it's the same idea that you should interpret things harmoniously across statutes if they're dealing with the same subject matter. So an example of this would be a statute that criminalizes certain behavior should be interpreted consistently with other statutes criminalizing that same behavior. A second linguistic canon is the negative implication canon, or expressio unius est exclusio alterius. What this means in Latin is the expression of one is the exclusion of the other. So this is usually applied when we have a list of or class of objects, say, that are explicitly mentioned. And then we have other things of the same general class or category that are excluded. So for example, let's say we have a statute that prohibits any horse, mule, cattle, hog, sheep, or goat from running upon land enclosed by a fence. Would that apply to turkeys? We would say no under this canon because turkeys are not specifically mentioned. We have a list of specific animals that does not include turkeys, and because Congress specifically named these other animals but did not name turkeys, this canon would tell us that turkeys are excluded. A third canon is the identical words presumption. This can also be called the presumption of consistent usage and meaningful variation. So there are two parts of this. The first part on consistent usage is that when Congress uses the same word in different parts of the same statute, it means those words to be interpreted in the same way. So that promotes internal consistency. The same word used over and over should be given the same meaning every time it's used. It's pretty much what you would expect. The meaningful variation canon basically says if Congress has been using one word and then switches to another word, then Congress must have switched for a reason. So the new word, the different word, should be given a different meaning than that first word. By switching words, Congress intended to change the meaning. So that's the meaningful variation part of this canon. Another linguistic canon is the rule against surplusage. Surplusage just means extra stuff. So there's, again, two parts of this canon. We don't want to have anything that is redundant or meaningless. So what that means is every word should have an independent meaning, and two different words should not be given the same meaning. Now, you could critique this canon by saying it's based on several questionable presumptions. For example, it's assuming that the statute was drafted with care, but as you all learned from week 1, the drafting process is convoluted and complex, and mistakes can occur. The second assumption is that each word was the result of thoughtful deliberation, which may not be true for those same reasons. And the third questionable presumption is that if the legislature had found the extra words, it would have removed them during this deliberation process. But nevertheless, this is a canon that courts commonly invoke to avoid having any extra language in a statute that just kind of is ignored, that falls out, right? You want to give each word in the statute meaning. Another linguistic canon is the associated words canon. In Latin, this is called nascitur associes, and you will see judges referring to it with this Latin name in their decisions. So all nascitur associes means is it is known from its associates. What this means is that when a word has more than one meaning, you should look at the surrounding words, so the context, to figure out how to interpret that word. This commonly comes up in lists. So for example, let's say we have a statute that makes it a crime to obstruct, resist, oppose, assault, beat, or wound a police officer. And let's say we have a situation where someone lied to the police about their age. And you want to figure out, did that person violate the statute? Is lying to the police about their age, obstructing, resisting, opposing a police officer? Well, a court looking at this question would try to figure out what is the common thing that these words have in common. And in this situation, the court might conclude this has to do with physical interference, right? Physically interfering with an officer. And because lying isn't physical interference, the court here concluded that the defendant did not violate the statute simply by lying about his age. Ejusdem generis also comes up actually quite frequently in decisions, and this is a special case of nocitur associes. This again comes up when you have a list, but this is used when you have a general catch-all term at the end of a list. In this situation, you want to look at what's the common unifying trait of the words in that list and use that trait to define that catch-all term. So let's look at another example. Let's say you have a statute that lists dogs, cats, horses, cattle, and other animals. So we have this phrase, and other animals at the end. That's our catch-all term that makes us different from, say, just a finite list of animals. So how should we interpret and other animals? Well, courts would say that it doesn't include every animal in the world, that these other animals in the list that Congress has taken the trouble to name, dogs, cats, horses, and cattle, are giving us an example of the type of animal Congress is talking about. So a court would try to come up with some type of unifying trait. It could be, for example, animals raised by people, which might include sheep, right, but not lions. So the way other animals is interpreted will be limited based on what common characteristic the others specifically named animals in this list share. Let's take another look at another example here. So the Endangered Species Act of 1973 has a provision that says it is unlawful for any person to take any endangered or threatened species within the United States. And then in the definition section of that statute, it defines the term take. It says the term take means to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, or collect, or to engage in any similar conduct. So let's say we're trying to interpret the word harm. What linguistic canon could we use? Let's go back again and look at harm. Here we have harm in this list: harass, pursue, hunt, shoot, wound, etc. So in trying to define the word harm, we would look at those surrounding words, which is nocitur associes. But we also have this other phrase, or to engage in other similar conduct. I'm going to go back and show you that statutory language again. Here we have this phrase at the end. This is a much more general phrase, something we would call a catch-all type of phrase. It doesn't really catch all though. You want to narrow this, any similar conduct, to, you want to limit what it means based on the words in the list. So that's an example of ejusdem generis, right? So when we're interpreting harm, that's not a general catch-all phrase. It's one of the words on the list, and we would look at the surrounding words, the context. That's nocitur associes. But when we're looking at engage in any similar conduct, that's a catch-all phrase, and that requires the specific type of nocitur associes called ejusdem generis. So what could be a possible unifier of the words listed in the definition of take? Direct force, for example, might qualify as a unifier, and that would exclude indirect force like habitat destruction, being any similar conduct. Okay, we're going to turn now to one of the cases, Yates v. United States, and this is a Supreme Court case from 2015. So first, what were the facts of this case? What you have is like a short excerpt from the case, so unfortunately you don't have the full background. But basically, this commercial fisherman caught undersized red grouper in federal waters. And he was an official got on the ship, saw that his fish were too small, and told him to, when he docks, to make sure he doesn't do anything with that evidence. But what he did was he ordered his crew members to toss those fish that looked too small into the sea. And he was convicted of violating this federal criminal section, 8 U.S.C. 1518, which states, whoever knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede a federal investigation violates the section. Okay, so what's the legal issue in the case? So the legal issue again is, what's the specific question the court needs to resolve here? Here the question is whether a fish is a tangible object under the statute. And the court here held that a fish is not a tangible object under the statute. So we're going to look at the different opinions to see how the court reached that conclusion and why the dissent didn't agree. So Justice Ginsburg here writes the majority opinion, or the plurality opinion, I should say. And she says the ordinary meanings are relevant, right? She looks at the ordinary meanings of tangible and object as defined in a dictionary. But then she applies nascitur associes. So she looks at the surrounding words, saying, oh, tangible object comes on this list of things that starts with any record or document. She therefore interprets tangible object to mean objects used to record or preserve information. So instead of meaning every tangible object in the world, she's limiting that meaning based on the context of the other words that appear in the list next to it. She also applies a justum generis, saying that if Congress wanted to capture physical objects generally, there would have been no need to include words like record or document that limit the meaning at the end. And she applies the rule against surplusage. Remember, this rule means that we don't want to have any language that's basically extra in the statute, language that has no meaning that we're just kind of throwing in as fluff. So that means that using that rule, a broad reading of tangible object would render these words record or document surplusage. Because tangible object, if it includes everything in the world, then we don't need to give these specific examples of record or document. Then we have Justice Alito, who issues a concurring opinion. That means that he agrees with the court's conclusion, but has a little bit different reasoning. So he's kind of focused on the list of nouns and verbs in the statute, as well as its title. He too applies nascitur and justum generis to the list of nouns. And he brings up email as an example of something similar to a record or document, but distinct from them. And in looking at the list of verbs, he stresses that that last phrase, makes a false entry in, only makes sense in the context of file keeping. He notes you can't make a false entry in a fish. Then we have the dissent. So here, it's an interesting grouping of the justices because Justice Kagan, who's traditionally known as a liberal justice, doesn't join Justice Ginsburg's opinion. Instead, she's joined an opinion with Justices Scalia and Thomas, who are much more conservative judges. And they write that the ordinary meaning of tangible object includes a fish. So they're really focused on ordinary meaning or plain meaning of the words tangible object. And to this, for this, they cite Dr. Seuss, one fish, two fish, red fish, blue fish. They also note that Congress wrote any tangible object and that any has expansive meaning. And they point out that this laundry list of verbs that Congress included further shows Congress wrote a statute with a wide scope, and that this should cover the whole world of evidence tampering in all its prodigious variety. How do they distinguish then the majority's reliance on nascitur associes and in justum generis? Why do they find those canons unpersuasive? Well, they say those canons don't transform or defeat the language that Congress chose. And those canons only come into play when the language is ambiguous, Here, because the dissent finds no ambiguity, they think tangible object is clear on its face. They don't need to apply any of these other linguistic canons. Alternatively, they say those canons actually support their own interpretation. They find a different unifier in applying a justum generis. And they say the unifier is anything that provides information, not things that preserve information, and a fish would fit within that category in this context. They also note that all the verbs don't have to match up to all the nouns. So that includes Unit 1.3, and next we're going to turn to policy-based canons.